How to defeat the trial penalty. The present, the future. First principles. Number one, your client has a constitutional right to a trial by jury. First principles. Number two, your client has a constitutional right to effective assistance of counsel. First principles. Number three, you cannot effectively advise your client to waive her right to trial and plead guilty unless you know all the facts available to you. First principles. Number four, your client cannot plead guilty and waive her right to trial unless that waiver is knowing and intelligent. Based upon these principles, you should not advise your client to plead guilty until you have reviewed all the discovery your client is entitled to under the Constitution and rules of criminal procedure. Instead, you should advise the court that your client will plead guilty to any crime your client is guilty of after you and your client have reviewed the discovery. If, after you and your client have reviewed the discovery, your client wants to plead guilty, you can inform the court that your client is accepting responsibility for the crime she committed. At this point, the court has a choice: refuse the partial plea and set the case for trial, or grant the partial plea and ask the prosecutor if he wants to go to trial on the other counts. At this point, the prosecutor has a choice: agree to a plea and forego a trial, or insist on a trial. The prosecutor will most likely agree to a plea and forego a trial. Here's why. Why would the prosecutor forego a trial? Because your client is pleading to what the prosecutor intended to offer originally, and the prosecutor believes your client will get the same sentence without having to take his case to trial. For the prosecutor, a no work, certain conviction. Why take the risk? Because you are now free to fight over your client's role in the offense, or over actual or intended loss, or number of victims, or special skill, or any of dozens of sentencing factors you would have had to stipulate to in order to get a deal from the prosecutor. And no appellate waiver, and your client will still get acceptance. What if you have to go to trial? Go for a complete acquittal, or tell the jury what your client did, that she accepts responsibility for what she did, and that even before trial she accepted responsibility for what she did. If the court stops you, your client can tell the jury that she accepts responsibility for what she did, but not for what she didn't do, and tried to plead to what she did do. And if the jury only convicts your client of what she was willing to admit to before trial, and you don't get acceptance, make acceptance of responsibility your first issue on appeal. And if you lose there, take it to the Supremes. Is there a risk that your client could end up worse off than if she had negotiated a deal with the prosecutor? Yes, of course. But weighed against that risk is the near certainty that in the vast majority of cases, your client will be worse off by negotiating a deal that locks her into all sorts of concessions you could otherwise win at sentencing or fight on appeal. My name is John May. I practice federal criminal defense. I regularly advise lawyers around the country on issues having to do with their representation of men and women under investigation or being prosecuted by the federal government. I am the author of Who Says You Can't? Strategies and Tactics for Becoming a More Creative Criminal Defense Lawyer. Now available from the National Association of Criminal Defense Lawyers, www.nacdl.org/who says. Learn more about my practice at johnmaycriminaldefense.com.